The case, known as Juliana v. United States, had been scheduled to go to trial in Oregon beginning on February 5. Among the issues to be determined at trial is whether the government's actions over the past several decades, the years when scientists began to understand and widely accept that greenhouse gas emissions cause global warming, violated the plaintiffs' constitutional rights. The feds have been desperate to get out of this case or halt it. In June, the government filed an unusual petition, rarely granted, that would allow it to circumvent a trial altogether. In other words, the government maintains that it would face a monumental task were it forced to sift through climate science evidence and records of policy discussions at the federal level. The case has already broken new legal ground in getting a district court judge to declare that the plaintiffs have a constitutional right to a stable climate. I think that shows that they're in a pretty desperate position right now, Alex Losnick, one of the plaintiffs, who is a student at Columbia University, said of the federal government. I would say I'm definitely glad that we're taking a step forward, and hopefully this is a step that moves closer to trial, he said in an interview. Losnick said the government may face a skeptical panel, given the Ninth Circuit's recent history. These are the big leagues in terms of the Ninth Circuit. The Ninth Circuit has made quite a few decisions in the last year that have been adverse to the Trump administration, he said. The plaintiffs are eager to get on with the case. Every week, or even every day, that our trial is delayed is time I spend further worrying about the stability of our climate system and the security of my future, said Kelsey Juliana, a 21-year-old plaintiff from Eugene, Oregon. Julia Olson, co-counsel for plaintiffs and executive director of Our Children's Trust, the advocacy group that brought the suit, said the government's argument makes little sense in light of the research her side has been able to do with far fewer resources. She said the government is making a ludicrous proposition that the federal government can't handle discovery in this case when a group of young people and their pro bono lawyers can. Olson and Phil Gregory, a co-counsel for the plaintiffs and partner with Kotchet, Pittry and McCarthy, LLP, in Burlingame, California, said there is an urgency to their case given the speed with which climate change is taking place, and the Trump administration's policy moves to undo emissions cuts. President Donald Trump has called climate change a hoax, and his cabinet officials have denied the scientific link between greenhouse gas emissions and global warming. There's just such extreme urgency right now to have these constitutional infringements addressed by our courts with the full factual records, Olson said. This constitutional case needs to be heard and not further delayed, Gregory said. Gregory said the plaintiffs plan to put the science on trial, with scientists taking the stand to back up the scientific basis for their position, while the government has the opportunity to counter it. What we're going to be putting on in the courtroom is science, and they're going to be putting on a different smoke and mirrors trial, Gregory said of the Trump Justice Department.